Following our discussion on permissible activities for unlicensed assistants, it is essential to examine what specifically constitutes unlicensed real estate activity, and under what circumstances certain individuals or entities are exempt from the licensing requirements established by the Arizona Department of Real Estate, ADRE. Understanding these distinctions is fundamental for compliance and for protecting both the public and real estate professionals from unintentional violations of the law. This section ties directly into ARS Section 322122, which clearly prohibits any person from acting as a broker or salesperson without first obtaining a valid license issued by the ADRE, and ARS Section 32-2121A, which outlines specific exemptions to licensing. Unlicensed real estate activity occurs when an individual performs acts that require a license for another and for compensation, without holding an active real estate license. Under ARS Section 32-2101-48, these acts include listing, selling, purchasing, renting, leasing, managing, exchanging, or negotiating the sale, lease, or purchase of real property for others in exchange for payment or the expectation of payment. It also includes advertising oneself as being able to perform such services or engaging in referral or commission-based arrangements without proper licensure. For example, if an individual named Paul, who is not a licensed agent, assists a friend in selling a home by negotiating the price and then receives a $500 finder's fee, Paul has engaged in unlicensed real estate activity. Even though the transaction was informal, it still meets the statutory definition because Paul acted on behalf of another and received compensation. Similarly, if an unlicensed property manager collects rent for multiple property owners or advertises homes for sale, they are performing acts that require a license. These violations expose individuals to civil and criminal penalties under ARS Section 32216-5A, which allows the ADRE to impose cease and desist orders and fines, and in some cases, refer matters for prosecution. Advertising is another area where unlicensed activity frequently occurs. According to Commissioner's Rule R4-2 8-502A, all advertising must identify the employing broker and must not be misleading. If an unlicensed person markets properties online or through social media and gives the impression of being a real estate professional, they are engaging in unlicensed practice. For instance, if someone posts, "Contact me to find your dream home," without being licensed, they are unlawfully holding themselves out as a real estate agent. The law's purpose is to prevent unqualified individuals from misrepresenting their expertise and misleading consumers. However, ARS Section 32-2121A provides several important exemptions where individuals may perform real estate-related activities without holding a license. These exemptions are narrowly defined and apply only when specific conditions are met. The first major exemption applies to property owners, lessors, and their regular employees. Under ARS Section 32-2121A1, a person who owns or leases property may engage in acts of selling, leasing, or managing their own property without needing a real estate license. For example, an individual who owns an apartment complex can lease units or negotiate rental agreements for that property without licensure. Similarly, a salaried employee of that property owner, such as a community manager or leasing agent, may show units, collect rent, or handle maintenance requests, as long as they receive only a regular wage and not commission-based pay. The key distinction is that these individuals are acting as employees of the property owner, not as independent contractors or representatives of others for compensation. Another exemption applies to attorneys acting within the scope of their duties. Under ARS Section 32-2121A2, licensed attorneys may perform real estate-related tasks incidental to their legal practice, such as preparing deeds, handling closings, or executing property transfers for clients. However, if an attorney engages in real estate brokerage for compensation outside of their legal work, they must obtain a license like any other professional. Additional exemptions under ARS Section 32-2-121A include court-appointed representatives, such as executors, administrators, trustees, guardians, or receivers, when performing duties within the scope of their court appointment. For example, a trustee selling estate property under a probate order does not require a license. Government officers or employees, such as those working for the Arizona State Land Department, when performing official duties related to state or federal property transactions. Cemetery brokers and salespersons, who are licensed under a separate statutory section, ARS Section 32-2194, and are regulated independently of traditional real estate licensees, public utilities, and their employees. When acquiring, managing, or disposing of real estate incidental to utility operations, such as easements or right-of-way acquisitions, isolated transactions by individuals, such as selling a single parcel of land owned by the seller, provided it is not part of a pattern of real estate sales conducted for compensation. These exemptions are carefully limited to ensure that only qualified individuals engage in professional real estate representation. The Arizona courts have upheld this distinction to protect consumers and maintain the integrity of the real estate industry. In cases where individuals repeatedly use exemptions to disguise commercial real estate activity, the ADRE may determine that those individuals are acting as unlicensed brokers and pursue disciplinary action accordingly. It is also important to note that real estate referral networks and online advertising platforms must comply with Arizona's licensing laws. Even if a person or company is located out of state, they may still fall under Arizona jurisdiction if they engage in activities involving Arizona property or residents. This ensures that unlicensed entities cannot bypass state regulations simply by operating digitally or across state lines. In every situation, the designated broker is responsible for preventing unlicensed activity within their firm. Under R4-28-1103, the broker must maintain control over advertising, communications, and staff conduct, ensuring that all persons performing real estate-related tasks are properly licensed or lawfully exempt. Failure to supervise or prevent unlicensed activity can result in disciplinary action against the broker under ARS Section 32-2153A21. Review Summary. In this section, we learned that unlicensed real estate activity occurs when a person performs acts such as listing, selling, leasing, or negotiating real property for another and for compensation without a valid license, as defined under ARS Section 32-2122. Violations can result in fines, cease and desist orders, or criminal penalties under ARS Section 32-2165. Exemptions to licensure exist under ARS Section 32-2121A and include property owners and their regular employees, attorneys acting within their professional duties, court-appointed representatives, government officials, public utility employees, and individuals engaging in isolated transactions. The designated broker must actively supervise all activities within their firm to prevent unlicensed practice. Discussion. What is the key factor that determines whether an activity requires a real estate license? Answer. Whether the person acts for another and for compensation, as defined under ARS Section 32-2101, open parenthesis, 48, close parenthesis. Can a salaried employee of a property owner lease and manage that owner's property without a license? Answer. Yes. Under ARS Section 32-2121A1, as long as the employee receives only a regular salary and not commission-based pay. Why are exemptions to licensing requirements limited and specific? Answer: to protect consumers and ensure that only qualified, supervised individuals engage in real estate representation. What statute governs penalties for engaging in unlicensed real estate activity? Answer: ARS Section 322165A, which allows for fines, cease and desist orders, and potential prosecution. Who is responsible for ensuring that unlicensed activity does not occur within a brokerage? Answer: the designated broker, under Commissioner's Rule R4-28-1103, closing remarks. The distinction between licensed and unlicensed real estate activity forms one of the most important pillars of Arizona's regulatory system. The licensing requirement ensures professionalism, accountability, and consumer protection. Exemptions exist only for specific, narrowly defined roles where the risk to the public is minimal. Every broker and licensee must remain vigilant in recognizing and reporting unlicensed activity while maintaining oversight within their firms. By understanding these principles, real estate professionals uphold the integrity of the industry and safeguard public trust in Arizona's real estate marketplace.